Imagine a country that decides not to wait for Europe. While the EU AI Act is only now starting to apply, Italy has just passed the first national law on artificial intelligence in the European Union. A bold move, but also a risky one, because the danger of conflicts with European law is always present. The law promises to put Italy in the front line of artificial intelligence regulation. But is it really a game changer? Or is it more of a political signal than a practical tool for businesses and professionals? I'm Giulio Coraggio, a technology and data lawyer at the global law firm DLA Piper. This is Diritto al Digitale, the podcast where we explore the intersection between law and innovation, where legal frameworks meet technological change. So, what has been approved and why? On the 17th of September 2025, the Italian Senate gave final approval to the new Italian AI law. The government had first introduced the bill back in April 2024, even before the EU AI Act was published on the official journal of the European Union. The timing explains why the Italian text has sometimes used different terminology or taken a slightly different approach compared to the EU AI Act. Parliament corrected several inconsistencies during the debates, but the law still feels more like a political signal, a way to say Italy is present in this debate, than a fully operational compliance tool. At the same time, the government has announced funding of up to €1 billion for AI, cybersecurity, and telecom projects. This aims to show that the law is not just about restrictions, but also about supporting innovation. So let's start. What are the regulators under the new Italian artificial intelligence law? The law gives central roles to two government agencies: AGID, Agenzia per l'Italia Digitale, the Agency for Digital Italy, which already coordinates digital transformation projects of the Italian public sector, and ACN, the National Cybersecurity Agency, responsible for national cyber defense. These are not independent regulators, like the Italian Data Protection Authority, for instance. That choice raises questions. The EU AI Act is strongly connected to the protection of fundamental rights. Many experts believe that independent authorities would have given stronger guarantees of neutrality, especially in sensitive areas such as employment monitoring or health data use. So what are the key sectors covered under the new Italian AI law? First of all, we have criminal law and deepfakes. The law creates new criminal offenses for harmful deepfakes and AI-enabled fraud, with penalties of 1 to 5 years of imprisonment. Companies should prepare internal policies for AI-generated content and mechanisms to cooperate with authorities if manipulated media is discovered. Secondly, minors and their protection are addressed. Children under 14 years old cannot access AI systems without parental consent. This means companies offering AI services in Italy must implement age verification tools and design services with child protection in mind. Third pillar is healthcare. AI is encouraged in medical research and diagnostics, with the principle of relevant public interest supporting data use. But companies must also respect the stricter safeguards under the upcoming European Health Data Space Regulation. Lastly, we have workspace protection. AI systems used in the workplace are subject to transparency and oversight obligations. Remember that in Italy, the Worker Statute and the guidelines from the Italian Data Protection Authority already limit employee monitoring, including through the usage of metadata of employees' emails. Deployers of workplace AI systems must expect short retention limits, possible involvement of trade unions, and the need for collective agreements. Another point of attention relates to copyright protection. Italy confirms that only works with creative human contribution can be protected by copyright. AI-generated works without human originality cannot. Companies using AI in creative industries like fashion, for instance, must carefully record the human role in creative process. And then there is the public sector. The law requires human oversight and explainability in public administration and judicial AI systems. For suppliers, this means stricter procurement requirements, including AI risk assessments and post-deployment monitoring. So how this law aligns with the EU AI Act? The EU AI Act entered into force on the 1st of August 2024. Some of its obligations already apply. Indeed, since February 2025, the provision that ban prohibited AI practices became applicable. Then in August of this year, we had the rules for general purpose AI systems that became applicable with their obligations on transparency, training data summaries, and cybersecurity safeguards. And then from August of next year, obligations for high-risk AI systems will become applicable, such as most of the other obligations under the EU AI Act. The full package will become applicable from 2027 because there will be the need of coordination with other pieces of legislation. The Italian law cannot replace or contradict these rules because EU laws prevail over national laws. For compliance, companies should use the AI Act as the backbone, and then the layer of Italian specifics, like the role of the Italian Digital Agency or the Italian Cybersecurity Authority, provisions on deepfake offenses, and the parental consent rules on top of the rules under the EU AI Act. So what is the playbook for companies that want to comply with these provisions? A recommendation would be to create a RACI matrix. This means clearly identify responsible, accountable, consulted, and informed roles for every AI project. It's part of the AI governance framework that any company needs to have in place. This helps clarify who does what, both inside the company and when engaging with regulators at the local level and at the European level. What changes for lawyers? There are specific provisions on the intellectual professions that include also the work of lawyers, notaries, and accountants. They must now address the role, the usage of artificial intelligence in their engagement letters, for instance, with clients, in order to make transparent that their work is supported by the use of artificial intelligence. For lawyers, this means explaining whether AI tools will be used in delivering services, how client data may be processed, and what safeguards apply. Since August 2025, then companies of procuring and integrating general-purpose AI models must request for providers detailed documentation, training data information, evaluation metrics, risk management, and security measures. And for high-risk projects, additional obligations apply, such as the need to put in place a conformity assessment, a quality management system, a data governance policy, a human oversight mechanism, and a post-market monitoring. What changes in the workplace? When AI is deployed in employment, it's necessary to align with Italian labor law, Italian privacy law, with collective agreements that might integrate the obligations that are provided under the EU AI Act. When it comes instead on copyright protection, it's necessary to keep audit logs showing human input in creative projects, for instance, in the creation of a marketing campaign or in the creation of a new collection in the fashion sector. It's necessary that a proof of the human contribution is collected and that training data are lawfully sourced. So what's going to happen Next, the Italian law is ambitious, but not final. Coordination with the local authorities and sector regulators will be critical. And once the EU AI Act is fully operational in 2026-2027, Italy may need to revise parts of the law to avoid duplication and ensure consistency. In short, the law is a starting point, not the finish line. So, here are my questions to you. Will the choice of non-independent Italian authorities as central regulators for artificial intelligence actually work, or will it create confusion compared to an independent authority? How will the new duties for lawyers and intellectual professions change the way client relationships are managed? And are companies already receiving the documentation they need from their AI providers, especially in relation to general purpose models? Email me your thoughts at giulio.coraggio@dlapiper.com to discuss about these topics. And if you found this episode useful, subscribe to the podcast, turn on the bell so you don't miss future episodes, and please leave us 5 stars on Apple Podcast or Spotify if you liked this episode. I'm Giulio Coraggio, this is the podcast Diritto al Digitale. Arrivederci.